Sorry na, alam niyo lahat.
Good afternoon, everyone, and welcome to Empowermonth, Empowering Women by Emphasizing Domestic Rights, a webinar on domestic rights and domestic violence. This is part of LAPCG's celebration of Women's History Month. We are also live on Facebook, so to those following us there, thank you for joining us and good afternoon. Today, we are joined by three esteemed presenters from the legal profession to discuss these issues. To start us off, I would like to call on our Consul General Edgar B. Badajos for his welcome remarks.
Hi, good evening, Maynard. And good evening to all our guests this evening, this morning, and this afternoon. And to all our speakers, thank you for joining us. I'm delighted to welcome everyone to this webinar on domestic violence. I believe that this is going to be the last project of the Philippine Consulate in celebration of Women's History Month, a month that I believe has been very productive in highlighting and emphasizing the contributions of women in our society. I want to again especially thank our three speakers today who will be sharing their knowledge on this issue. And of course, most importantly, the remedies, both legal and administrative, that victims of domestic violence may pursue to protect themselves and other members of their families from further acts of domestic violence. Domestic violence is a very difficult issue, a difficult topic to discuss because it concerns people who are supposed to be caring for one another and to protect each other from harm. And of course, for those who are married, this sounds very familiar, to have and to hold, for better, for worse, for richer, for poorer, in sickness and in health, to love and to cherish until they are parted by death. It concerns the home, a place that's supposed to be a haven of safety for everyone. Normally, when we are outside the home that we feel threatened or afraid, that we need to be on alert. But with domestic violence, even the place you would normally consider as our refuge becomes a place of horror and the last place on earth that we would like to be in. Domestic violence likewise signifies a breakdown in the family bond. Because of this, it hits us more personally than any other kind of violence. And because domestic violence involves people who are supposed to be taking care of each other, the usual response when it occurs is to keep it a shameful secret. As a result, many incidents of domestic violence go on either unreported or underreported, thereby allowing the problem to fester and the underlying issues to become bigger and the violence to become even harsher or perhaps even deadlier. Despite advances in society to address domestic violence, it is troubling to note that the problem remains pervasive, as pervasive as in the year 753 BC, during the reign of Romulus in Rome, when wife beating was accepted and socially condoned. Let us consider the following statistics. Worldwide, UN data shows that 1 in 3 women have experienced physical or sexual violence. And when accounting for sexual harassment, this figure is even higher. Across the globe, 27% of women aged 15 to 49 years who have been in a relationship report that they have been subjected to some form of physical and or sexual violence by their intimate partner. A UN Population Fund report published in April last year estimates that there was a 20% increase in domestic violence across the UN's 193 member states during the COVID-19 lockdowns early in the year. Closer to home in Los Angeles, the Los Angeles police respond to about 48,000 domestic violence calls each year. LAPD file more than 15,000 reports and make over 6,000 arrests for domestic violence each year. The Los Angeles District Attorney's Office sees about 11,000 domestic violence cases each year, or about 200 new cases weekly. Domestic violence crimes are reported to have been on the rise since 2015, when they spiked 20.2% in Los Angeles alone. As far as the Philippine Consulate General in Los Angeles is concerned, I wish to note that many of the requests for legal assistance that we receive from members of the Filipino American community under our jurisdiction involve cases of domestic violence, besides sexual-related offenses. It is in light of the continuing pervasiveness of domestic violence that we have decided to hold this webinar to shine light on the problem and hopefully, with the help of our three subject matter experts today, empower some of the victims by arming them with information they can use to shield themselves from acts of domestic violence now or in the future. With this, I welcome everyone once again to this webinar. Let's all say no to domestic violence. Thank you and mabuhay. Thank you, Maynard. Back to you.
Thank you, Consul General Badajos. We will now move on to our speakers for today's seminar. If anybody in our audience has a question, please type it in the chat box, and we will address the same during the Q&A portion of our webinar. Our first presenter will give us a background on domestic violence and some of the significant issues connected therewith. He is a partner at Ross Law APC, a boutique law firm in Torrance, California. He is the firm's lead trial attorney, handling all aspects of family law-related matters. He has zealously litigated high-conflict family law disputes, mediated cases, and obtained or defended restraining orders. Prior to Ross Law APC, he was a prosecutor with the Los Angeles County District Attorney's Office from 2007 to 2020, where he conducted jury trials to verdict and was member of the Sex Crimes Division and the Victim Impact Program. He has successfully tried cases involving sexual assault, child molestation, child abuse, domestic violence, murders, and special circumstance murders. He has lectured on trial techniques and criminal investigations for the Los Angeles Police Department, the Los Angeles Sheriff's Department, the Los Angeles County District Attorney's Office, the California District Attorneys Association, and the California Clinical Forensic Medical Training Center. Ladies and gentlemen, Attorney Adrian Gidaya Rojas.
Thank you, Deputy Leon, for that introduction, and also to Consul General Badajos for inviting the Philippine American Bar Association to be a co-sponsor for tonight's event, empowering women and emphasizing domestic rights. Of course, this would not be a lawyer event without a disclaimer. So before I do my portion of the event, I do want to do a short disclaimer. The views expressed during this presentation this evening or at other events sponsored by the Philippine Consulate General Los Angeles and the Philippine American Bar Association are those of the individual speaker and not necessarily of PCG LA or PABA. Presentations at PCG LA or PABA events or the presence of vendors at PCG or PABA events does not constitute an endorsement of the vendors or speakers' views, products, or services. This presentation and anything discussed during this presentation should not be construed as creating or intending to create an attorney-client relationship. Of course, if you require legal assistance, you should immediately contact law enforcement or contact an attorney for assistance. And with that, let me share my screen. Can you all see it? All right, so this evening, let's see. Can I get a thumbs up? Can you see my screen? No? Let's see, give me 1 second.
Sir, do you want me?
How about now?
Yeah, just
Yes?
Yeah.
Yes?
Just slideshow now. Yeah.
Yeah.
Fantastic. All right. Perfect. So this evening, obviously my portion of the presentation is a mere 15 minutes. And as Consul Badajoz stated, domestic violence is an issue and a topic that can span several hours and in fact, several days. There are seminars that last weeks with regards to this issue. But for purposes of this evening, I do want to just stress that this is an overview of domestic violence issues and victims' resources, as well as what you can do if you find yourself in a situation where you are in an abusive relationship. For purposes of tonight, I will cover what is domestic violence, what does the law consider as domestic violence, and what are issues that affect the Filipino-American community, and seeking protection if you are in a domestic violence relationship, and resources for survivors of domestic violence. Now, the topic of domestic violence, we hear that term a lot, and of course, that begs the questions of what does that mean? And domestic violence can take many forms. There is emotional abuse, and that comes in the form of yelling, name calling, belittling. There is financial abuse. Oftentimes we see instances where a husband controls the finances. And in many of our divorce cases, a wife will come to us and say, we've been married for over 25 years and I've never had access to our bank accounts or our checking accounts. And we may laugh at that and say, you know, that's actually pretty funny because she may spend all the money shopping or on frivolous expenditures. But in some situations where that is coupled with physical violence and emotional abuse, that is yet another form of abuse that this spouse has to go through. And we also have the more common abuse of physical abuse. And of course, this is what I will spend the most of my time on tonight. And when we talk about physical abuse in the criminal context, the most common charges that we see in court are domestic battery, corporal injury on a spouse, cohabitant, or child's parent, criminal threats, and stalking. And just briefly, domestic battery is defined as using force or violence against a spouse or former spouse, a fiance, a dating partner, or the other parent of your child. And corporal injury on a spouse, cohabitant, or child's parent includes willful infliction of corporal injury resulting in traumatic condition upon a victim who is either a spouse or former spouse, cohabitant or former cohabitant, a fiance, or someone with whom the offender has had an engagement or dating relationship, or the mother or father of the offender's child. Now, the difference between these two charges is that in corporal injury on a spouse, cohabitant, or child's parent, the law requires some type of visible injury or non-visible injury so long as it can be documented medically. So if you have internal hemorrhaging, that would constitute a violation of Penal Code Section 273.5, whereas a violation of simple domestic battery, those typical instances occur when a husband pushes a spouse or slaps a spouse. And in that situation, you would not necessarily have a physical injury that is visible for the court. Now, there's also criminal threats. And when we talk about criminal threats, what we're talking about is during these incidents of domestic violence, a lot of times the abuser will say things like, I will kill you, or I will kill all of us, or I will kill your family. And if the victim perceives that threat to be true, the abuser can be found guilty of criminal threats. And also we have the most common charge of stalking. A lot of times when we have the victim who wants to leave the relationship and wants to become a survivor, attempts to leave the relationship as much as she can, and for whatever reason, she's unable to because the abuser keeps on following her. The abuser keeps on taunting her, and the abuser will not let her go. And in that situation, we have instances of stalking. And you can imagine if, as a victim, it is that much harder to leave the abusive relationship because not only have you had prior instances where he is abusing you, but here you are trying to leave the relationship, but this abuser is still taunting you and asking you to come back, or even more so, causing further trauma by following you in your workplace, following you in your new home, or even worse, doing things that are more egregious than what they've done in the past. Those are the most common types of scenarios that I've come across as a former prosecutor. And even now, when we seek domestic violence restraining orders in family court, those are the types of scenarios that we see when it comes to seeking domestic violence restraining orders. Now, if you've ever known someone who's in an abusive relationship, or if you yourself are in an abusive relationship, or you've seen anybody in an abusive relationship, you will know that it's a lot easier to say, why don't you leave? It's easier said than done. And there are a lot of factors why leaving an abusive relationship may take some time. And I've heard survivors tell me various things. They've told me in the past, I believe that he would never change. I felt that no one else would love me. I felt that no one would believe me. And as Consul General Badajos alluded to earlier, culturally, the Filipinos, we have this notion of nahihiya, like we don't want to bring shame to our family, right? Like we don't want to call the police, because if the police come to our home, the entire neighborhood will come and look at us, and the next thing you know, we'll be the talk of the neighborhood. And did you hear that? Did you hear what happened to so and so? He was beating her, or there was a fight, and it becomes the chismes of the town. That's part of the reason why I think culturally it's more difficult for Filipinos to report this type of abuse or this type of trauma. Sorry. Now, the one case that I can think of was a case that I handled as a prosecutor, and it was a Filipino couple from Carson. I was assigned to the Compton courthouse for about 12 years. And part of that was covering the cases that came out of Carson. And many of you know that Carson is heavily populated with Filipinos. The case that I dealt with was a Filipino couple. They were here undocumented. They did not have immigration paperwork. They were together for 14 years. And the victim at that point told me that he began abusing her from day one. And I'll never forget this case because it was the one case where I learned a new Tagalog word, which was bolo, B-O-L-O. And the reason why I learned that was because when the neighbor called 911, the police arrived, ambulance came, the victim was basically unrecognizable. She was brought to the hospital, and I responded to the hospital to interview her. And I looked at her, and all I could see was blood and basically open wounds. And I asked her what happened, and then all she could say was bolo, bolo. And I said, I don't know what that means. What are you talking about? And what she told me was essentially that her husband slashed her with a bolo many times. You couldn't recognize her face. She was slashed throughout her body. Thankfully, she survived. And in interviewing her, I asked her, how long has this been going on? And she told me for 14 years, he's been abusing me. And she started crying and she said, I wanted to keep my family together. We're a religious family. And I didn't want to bring shame to my family. And she also talked about other factors such as control. But the one factor she talked about was the fact that she was afraid of reporting the abuse to the police because they were both undocumented and they did not have immigration paperwork. And in fact, I'm pretty sure if the neighbors didn't call the police, she probably would not have called the police, even though she was laying in a pool of blood in this situation. So we have in the Filipino community the traditional reasons of why victims don't report, such as fear of losing, losing the family unit. But we also have the added layers of the legal system, including immigration, and culturally we have added layers of bringing shame to the family. We have religion, and we have trying to keep the family unit together. Now, what do you do if you've been abused? Obviously, like I said, this is a lot easier said than done. The most important thing to do is to seek a place of safety. And by that, I mean, if you are in immediate danger, call 911, find someone who can help you, a family, a friend, a relative. Once you are in a safe area, it's important that you plan. You try to plan as much as you can and create a safety plan moving forward. And once you have a safety plan, that includes seeking protection from the court. And part of that, obviously, is documenting any injuries or documenting any property damage that you have had over the course of the abusive relationship. And we're living in the age of cell phones, in the age of emails, in the age of social media. A lot of the abusers nowadays send things via text message. They leave abusive voicemails, and you have your cell phone handy. If as much possible, you take screenshots of the text messages, you save the voicemails, you take photos of the damage, you take photos of your injuries, because these are things that you will need in court down the road. And that leads me to the next practical step of tonight's topic of my portion, which is the remedy that you would have in terms of seeking protection. Now, there are two types of protection that you would have with regards to a restraining order. There is a criminal protective order and there is a domestic violence restraining order. Now, the criminal protective order is something that you have no control over. The criminal protective order is something that's associated with a criminal court filing. So if you call the police, a report is taken and a criminal case is filed, almost automatically the criminal judge, the court, will issue a criminal protective order, which protects you from having any type of contact from the abuser. However, if the court does not issue a protective order, let's say, for example, you call the police come and the district attorney or the city attorney decides not to file a criminal case, then what are you left with? You're left with the domestic violence restraining order at that point, and that is filed in family court. This requires you to actually go to the courthouse yourself and to file the paperwork. And there are 4 forms that you will need, at the very least, 4 forms that you will need to initiate the domestic violence restraining order. And that is the request for the domestic violence restraining order, the confidentiality form, and the notice of hearing, and the temporary restraining order. And essentially what that means is that you are filling out this paperwork and the judge will review the paperwork on its initial face value. So your paperwork has to be persuasive to the judge. What I mean by that is you will not be interviewed by the judge. You will not be asked to testify on the initial paperwork. So your initial paperwork has to be as truthful and as convincing as possible. And by that, I mean including as much details as possible. And you file that with the court at the nearest courthouse where you live, or in downtown LA. And once that restraining order is granted, it's good for 21 days. And after that, you would be required to have an actual hearing if you want a restraining order that's more than 21 days. And these restraining orders can last for up to 5 years. Now, if you want a restraining order for more than 21 days, you will have to actually do a hearing. And this involves testimony. And the basic preparation for a actual domestic violence restraining order hearing is that you provide as much evidence as possible and that you prepare as much as possible. You write down the incidents of abuse. You bring documents. You bring text messages to the court. You bring photos. You bring medical records, police reports, and witnesses. You cannot bring in declarations from witnesses who heard X, Y, and Z. The actual witnesses have to come to court to testify about what they saw and what they heard. Otherwise, the court will exclude any type of written declarations from those witnesses unless they are actually in court to testify. Now, this can all seem very overwhelming, but in every courthouse in the county, there is a self-help office where they will provide you the basic understanding and knowledge on how to fill out protective orders and how to prepare for these types of hearings. Obviously, if it gets more complicated than you can handle, you would probably need to consult with an attorney at that point. I do want to finish off with, let's see, the resources for victims and survivors. There are hundreds of agencies in the state of California that provide counseling as well as shelters for victims and survivors of domestic violence. And this isn't just limited to the victim herself or himself. It includes the family members, including the children. So if you are ever in a situation where it comes to the point where you need to leave the home, these are the types of resources that are available to you. And I've only listed 5 here, just in the general area of LA. But like I said, there's several hundreds throughout the state. You can seek help from your local church. You can seek help from any other type of agency, including the YWCA, and also police stations. They have resources for shelters and crisis centers if you're ever in a situation of domestic violence. And I believe my time is up at this point. So I will pass it on to the next speaker.
Thank you, Attorney Rojas. If you have any questions regarding Attorney Rojas' presentation, please type it in the chat box and we will address it during the Q&A. Next is immigration and domestic violence crossover issues. And we have 2 excellent presenters for this issue. Our next presenter is an associate attorney at Loke Walsh Immigration Law, where she focuses exclusively on business and family-based immigration law. Prior to joining LWIL, she was an associate attorney at Reeves Immigration Law Group, where she represented clients in a variety of immigration law matters, such as adjustment of status, removal of conditions, VAWA self-petitions, U visas, DACA, employment-based applications, and removal defense. She attended the University of Wisconsin-Madison, where she obtained her Bachelor of Arts degree in Communication Arts and Certificate in Asian American Studies. She earned her JD from the University of St. Thomas School of Law in Minneapolis, Minnesota. And lastly, she is a board member of the Philippine American Bar Association of Los Angeles. Ladies and gentlemen, let's welcome Attorney Maridex Abraham.
Thank you very much for that introduction, Consul Maynard, and thank you to Consul General for inviting PABA to present on this very important topic. Attorney Marlon Baldomero and I will be presenting on the crossover issues between domestic violence and immigration. He'll be focused on the relief tied particularly to those who are married, while I'll be talking about the U visa, which is relief for any victims of crime. Again, it'll be an overview, so won't get too much into details, but it's important to know the types of relief, especially if you are someone who's undocumented. Before I begin my part of the presentation, I would also like to read the disclaimer. So as Adrian mentioned, the views expressed during presentations made today or at other events sponsored or co-sponsored by the Philippine Consulate General, Los Angeles, and Philippine American Bar Association are those of the individual speaker and not necessarily of the PCGLA or PABA. Presentations or events or the presence of vendors at PCG or PABA events does not constitute an endorsement of the vendors or speakers' views, products, or services. This presentation and anything discussed during this presentation should not be construed as creating or intending to create an attorney-client relationship. If you require legal assistance, you should immediately contact an attorney. And so now I'll share my screen. Can everyone see my screen? Great. Okay, so I'll be giving an overview of the U visa. Basically, the U visa is relief for victims of certain crimes. And there's a list of qualifying crimes that could constitute eligibility for this type of relief. The victims would have had to suffer mental or physical abuse, and they'd also need to be helpful to law enforcement or government officials in the investigation or the prosecution of this crime. This type of relief was created by Congress as a means to protect victims of crime. As was touched upon in the previous presentation, it's difficult to come forward as a victim, let alone a victim who's undocumented. So this was a way to protect the person who was a victim of the crime and allow them to feel more comfortable coming forward to law enforcement without the fear of being sent to immigration or detained or deported. And conversely, it was also helpful to law enforcement agencies because it allowed them to offer protection to victims who may not have status. And it also aided them in the investigations as well. The next slide is not an exhaustive list of qualifying crimes. As you can see, there are many, and there's other types of related crimes that could qualify for a U visa. And how a person will know this is, let's say somebody, something happens to the person. They either get abducted, or they were held hostage, or there was a domestic assault. By coming forward to the police in this incident, you might have a police report or have given a statement to police, which at that point they could certify the crime for you and at least confirm that you were helpful in providing them information on the crime. So you don't necessarily have to have brought the case to court. The police officers and the law enforcement agency that they belong to can certify the crimes, or can certify that you were a victim and that you were helpful. And this is just the criteria, just step by step. First, you would have had to be a victim of the criminal activity, and you would have had to suffer abuse. And abuse can be physical or psychological. Obviously, it's a bit easier to document the physical abuse. While it's really difficult, I think, while the event is happening, but if it's something that's ongoing, make sure to take photos of any harm, like if you have bruises, cuts, or any lacerations, document everything, because that would be helpful in proving your case. The mental abuse, that type of abuse is harder to show, but and it is also difficult to seek counseling, but that's one way to show that you've been abused psychologically, is if you end up having trauma, going to a psychologist and coming forward and discussing discussing the trauma that you faced as a result of the crime imposed upon you. You could also write a statement, a victim statement, just documenting all the ways you've suffered. If you can't sleep, or if you're more hyper vigilant as a result of the criminal activity, or if you're less trusting. Those are all important things to document your abuse. And you do have to have information about the crime itself. So that's where, when you do come forward to law enforcement, detailing the event to the police officer. And because it's, you're the victim, you do have access to this police report. And, the officer, will, some of them, they see this type of stuff every day and they are willing to work with you. Lastly, you have to be helpful in the investigation. So either by, filing a report with the police, or if it comes down to prosecution, if you're willing and able, to be a witness or to provide a statement to prosecution. And the crime would have had to occur in the United States, and it would, and violating US laws. So that means the crime, even if it was committed by a US citizen, it would have had to happen under US law. And then again, there's other criteria about inadmissibility. And that's more so related to the immigration laws. There can't be other reasons for USCIS or for immigration agencies not to allow you to have relief. So like if you've committed crimes yourself, or if there is some high level of fraud, you have to watch out for those as well. So waivers might apply in your case. So this is just bare bones of the process. And I only included the process after the incident already happened. So the first thing that you will need is Form I-918 Supplement B. Now this supplement, this is completed by law enforcement. So either a police officer in the jurisdiction where the crime took place, usually it's somebody who is in charge of the U visa unit. So that person can review your case and sign off that you had been helpful in the investigation of a crime. And they'll also include the specific statute that the person, or that the other person was charged under. If the case did go to court, you could also get it signed by the prosecution's office. So once the law enforcement agency has certified that you were helpful in investigating the crime, you'll have to complete the form I-918. And this is basically information about yourself and your immigration history. And you'll have to sign off on that form. Together with those forms, you'll have to file the U visa application with supporting documents, which you'll already have. So examples of these documents are police reports, photographic evidence, of any physical abuse, witness statements if you have any, also text message. So if there is, a high level of harassment or threats, that's also important to include in your U visa application. You also might want to file a work permit application, and this application, it's for when you are actually approved for a U visa. The unfortunate thing about U visas is that there's a limited amount of U visas approved or allowed to be approved each year, and that number is 10,000. But there are several more U visa applications filed each year. So even if your case is approvable, you'll be put on a waiting list, and the USCIS might find that your case, is strong enough, but they can't grant you the visa. But in the meantime, they can grant you permission to work. So that's why it might be a good idea to actually file the work permit along with the U visa application and the filing fee for the work permit. The U visa application itself is actually free. And if you do have issues based on certain other reasons that would make you inadmissible, a waiver, also file the waiver application as well. And some relief stemming from the U visa, filing the U visa petition. So if you're approved, your U visa is valid for 4 years. And while you're in U visa, U non-immigrant status, you can continue to renew the work permit each year. Typically, a work permit for the U visa is valid for 1 year, sometimes 2. But while you're in U status, you could keep renewing your work permit so that you can work in the United States. And you can extend your U visa status as well. So before the 4 years is up, you could file for an extension. However, you might actually want to file for your green card instead. So after 3 years of valid U non-immigrant status, you can file for your green card application, which is better because it allows you to permanently stay in the United States and allows you to travel in and out of the United States. It's also a pathway to citizenship. So once you get approved for your green card, you could then file for your citizenship after a certain amount of time. Also, if you have family members and you receive, and your U visa application is approved, your family members can obtain derivative status through your U visa as well. And typically it's spouses and children. And that wraps up my section of the presentation, and I will turn it over to Marlon.
Thank you, Attorney Abraham. Again, please type in the chat box any questions you may have regarding our first 2 presentations. Our final speaker for the day obtained his Bachelor of Laws degree from the University of the Philippines College of Law and his undergraduate bachelor's degree in political science from the Ateneo de Manila University. He migrated to the United States in 2006. 2 years later, he earned his Master of Laws degree from Whittier Law School with a focus on the U.S. legal system for foreign-trained lawyers. He obtained his license to practice law in California in 2008. Because of his background, he's very sensitive to the needs of Southern California's immigrant communities, particularly in the area of immigration law. He has helped countless of immigrants obtain legal permanent resident status and U.S. citizenship through the USCIS. He has also successfully represented clients in immigration courts and have helped them obtain positive relief in removal proceedings. He currently practices as a solo attorney in Long Beach, California. Ladies and gentlemen, Attorney Marlon Baldomero.
Thank you, Consul Maynard Malion, and I would also like to thank Consul General Edgar Badajos for providing us with this opportunity. Before I begin, I would like to share the same disclaimer as the other presenters. The views expressed during presentations made today at or other events sponsored or co-sponsored by the Philippine Consulate General, Los Angeles, and the Philippine American Bar Association are those of the individual speaker and not necessarily of PCGLA or PABA. Presentations at PCGLA or PABA events or the presence of vendors at PCG or PABA events does not constitute an endorsement of the vendors or speakers' views, products, or services. This presentation and anything discussed during this presentation should not be construed as creating or intending to create an attorney-client relationship. If you require legal assistance, you should immediately contact an attorney. Okay. So tonight, for those in the Philippines, this morning, I will be discussing the VAWA aspects of as a form of immigration relief. So let me try sharing my screen. Can everybody see my screen? Okay. So most of these slides were taken directly from the USCIS website. Continuing with the topic that Attorney Maridex was discussing, there are immigration relief for vulnerable members of our population. Attorney Maridex talks about crime victims, and I'll be talking about domestic violence and child abuse victims. Okay, so why is there a need for these types of protections for immigrants? Well, Congress recognized that immigrants are particularly vulnerable to crimes like human trafficking, domestic violence, and child abuse. And the reason for this are the following. There's a language barrier. Although most of us from the Philippines can speak English, not all of us are comfortable with the language or have a difficulty expressing themselves in English. Separation from family and friends, lack of understanding of US laws, fear of deportation, fear of law enforcement, and cultural differences. So because of these, Congress created several forms of immigration relief that are available to aliens who are victims. So one of these form of relief is called is under the Violence Against Women's Act, or VAWA. So VAWA provides immigration relief to victims of domestic violence. I believe Attorney Adrian earlier talked about or went over the definition of domestic violence. And it's important to point out that first, VAWA only applies in domestic violence scenarios. So if you're a victim of abuse or if you're a victim of a crime that is outside of a domestic scenario, then you might be eligible for the relief that Attorney Maridex talked about earlier, or the U visa. Okay. Congress recognized that immigrant victims of domestic violence may remain in an abusive relationship because of their immigration status and is often tied to their abuser. I believe that Attorney Adrian also discussed this earlier, that it may be difficult for victims of domestic violence to end their relationship, even though they are being victimized for a number of reasons, such as emotional blackmail and the threat of either getting deported or the threat of losing their opportunity to get a green card or to become a permanent resident. So fortunately, the US Congress has devised a solution or a form of relief for people who are in this scenario, and that is VAWA. So VAWA is a form of a self-petitioning relief that removes control from the abuser and allows the victim to submit his or her own application that is filed without the abuser's knowledge or consent. So why is this important? So ordinarily, an immigrant or a potential green card holder needs somebody to file a petition for them. So it could be a US citizen spouse, a permanent resident spouse, a parent, a child. But under normal circumstances, an immigrant cannot file a petition for his or her own self. And that is how the abuser can have control or power over the victim, is because the victim understands or may believe that the only chance of getting status here in the US is through his or her relationship with the abuser. So under VAWA, you don't need to be in that relationship anymore, or you don't need to convince or have your partner or your relative file the petition for you. You can do it yourself if you meet the eligibility requirements, which we will be discussing under this next slide. So who may file? Spouses, the abused spouse of a US citizen or a legal permanent resident. Okay, so again, the context of VAWA only covers domestic scenarios. Okay, so in the first example or in the first case, you need to be the spouse of a US citizen or a green card holder. So for example, if you are a fiance, if you're a boyfriend or a girlfriend, then unfortunately, this does not cover you. Okay. Now, children may also be covered by VAWA. And what this means is that you may be able to file VAWA if you are a child of a US citizen or a permanent resident. You don't need to wait for your parent to file the petition for his or her own self. If you qualify under this, you can file VAWA on your own. Parents can also be the beneficiary of a VAWA petition. Okay. But unlike children and spouses, only US citizen or only parents of US citizens can qualify for VAWA. And contrary to what many people believe, VAWA does not only apply to women. It applies equally to both men and women, despite the name. So what are the eligibility requirements under each category? So for abused spouses, you have to be married or you were married to a US citizen or legal permanent spouse. Okay, so if you're married, you can file VAWA right away. You don't have to file divorce. But in case you do file divorce and you are divorced from your US citizen or LPR spouse, you have a time limit or a deadline of 2 years within which to file the VAWA application. And the second requirement is that the marriage was in good faith. Good faith marriage means that the marriage is a real marriage, it's a bona fide marriage, and was not entered by the spouses for immigration benefits. So the requirements for abused children is you have to be the child of a US citizen or a legal permanent resident. And for abused parents, you have to be the parent of a US citizen. Now, the requirements that apply to all victims are as follows. First, you have to have the qualifying relationship to the abuser. So either a spouse, a child, or a parent. You have to have been subjected to battery or extreme cruelty by the abuser. So I'll go over this in more detail in the next slide. You have to have resided or resided with the abuser. So generally, to qualify for VAWA, you have to have been living at least for a certain period with the abuser. And normally this applies for cases that happen in the US. Okay. There are certain exceptions. If you're, for example, the victim of domestic violence while you're in the Philippines or outside the US, you might still qualify for VAWA if the abuser is an employee of the US government or part of the US military. Okay. Another possible scenario wherein someone would qualify for VAWA is, let's say you were here in the US, you suffered domestic violence. Because of that, you decided to go back to the Philippines. Okay. You can actually file VAWA while you're in the Philippines because the abuse happened while you were here in the US. And the last requirement is that you should have good moral character, which generally means that you should not have any criminal records. So I'd like to focus on what the definition of battered or subjected to extreme cruelty is under the law. So it includes, but it's not limited to, being a victim of any act or threatened act of violence, including any forceful detention, which results or threatens to result in physical or mental injury, psychological or sexual abuse or exploitation, including rape, molestation, incest, if the victim is a minor, or forced prostitution may be considered acts of violence. Other abusive actions may also be acts of violence under certain circumstances, including acts that in and of themselves may not initially appear violent, but that are part of an overall pattern of violence. So there are two important aspects of the definition that I want to go over. First is battered, as was discussed by Attorney Adrian earlier. If you suffered actual physical abuse, then you would qualify under the definition of a battered spouse. Now, subject to extreme cruelty is a little bit more difficult to define, but fortunately, the definition or the examples given here is not exhaustive. There are many types of, or there are many forms of cruelty that may qualify under VAWA, like being subject to emotional, financial abuse, and so forth and so on. So it's really a case-to-case basis. And if you feel that you have been a victim of domestic abuse, then make sure that you consult with an attorney to find out what your options are. Okay, so the benefits of VAWA is that, like I said, you don't need a petitioner. You can file the petition for yourself. Even if the petitioner or even if the abuser loses his or her status, it will not adversely affect the self-petition. Okay. Once you have a VAWA petition approved, this can be used as a relief to remove you from immigration court. You will get work authorization, and remarriage or marrying the abuser after the approval of the self-petition does not invalidate the self-petition. And you can also get a green card or adjust to lawful permanent status through VAWA. So to apply, there's a form. It's form IO360. You file it with the Vermont Service Center. Okay. Now, I'd like to end by going over the timeline of a VAWA petition. So if you file the VAWA petition in 2 to 3 weeks, you will get a receipt notice. In 1 to 3 months, you'll get a prima facie notice. What this means is that USCIS has reviewed your application and it looks like it's approvable. Okay. If there's no request for additional evidence within 5 to 7 months, you would get a your self-petition would get approved, and depending on the nature of your relationship with the abuser, you may be able to apply for adjustment of status immediately. Note that if you are an immediate relative, you can apply for VAWA. You can file the petition, the I-360, together with the adjustment of status, the I-485. And with that, I will conclude my presentation.
Thank you, Attorney Baldomero. We will now have a quick group photo with the three speakers. So turn on your.
Okay, please smile. 1, 2, 3. One more. 1, 2, 3. And now go to the next page. Okay, smile again. 1, 2, 3. 1, 2, 3. All right, thank you.
Moving on to the next part of today's webinar, I wish to call on Consul Maria Alni Gamble for the conduct of the Q&A.
Thank you, Consul Maynard, and we thank once again our presenters for their very illuminating presentations on the very important issue of domestic violence and the recourses available to victims. Now, we'd like to pose a few questions to our presenters. Number one would be, when can a victim apply for a U visa? And related to that is conviction of the accused a prerequisite before a victim can apply for a U visa?
Thank you for that question. And that's actually a really good question because there's no like real time limit on a U visa. I mean, obviously, the sooner you file after the incident occurred, the more recent your facts can be and the more detailed you can be in your application. However, you don't have to file the U visa right away. I've had clients actually file like after years have passed, for whatever reason. Perhaps they didn't know that the U visa was a form of relief, obviously being undocumented and not, being afraid to come forward. So there's no time limitation, but the sooner you file, the more detailed you could be in your memory, because sometimes a person, during the passage of time, memory might be more difficult to recall, but also a victim might want to forget about what happened to them. You're also, I guess, more in touch with the police officer or the law enforcement agency in that sense, but it doesn't mean that if you're not ready to file right away, it doesn't mean that you can't come back to the police station or the agency that the crime or that the incident occurred. A conviction also isn't necessarily, as long as you were helpful in the investigation.
Okay, thank you, Attorney Maridex. Now, related to that, I believe that one of the reasons why victims may be hesitant to approach law enforcement regarding their situation is with representation. Who takes care of the legal representation of victims? Any of our presenters may answer if they have information about this.
Could you clarify what's the context of the representation?
For example, when they file a case against the perpetrator, are they supposed to get legal representation themselves, or would the prosecutor's office take care of representing them, or would the government be providing legal representation for them?
Okay.
I can answer that question. So
you.
with regards to the criminal context, if you file a police report and a police report's taken and a criminal case is filed, the prosecutor is not your representative, is not your attorney. The prosecutor represents the state or the government. So in that context, you are still not being represented by an attorney. However, obviously the prosecutor, in prosecuting your case, since you are the victim of a case, the prosecutor does have your best interests in mind. But in terms of seeking representation, there are victims' rights attorneys, many of them out there, that can represent you as a victim's rights attorney to make sure that the prosecutor is doing their job, and also to make sure that the defense attorney, because obviously the accused has an attorney, to make sure that the defense attorney is not doing anything that is unconstitutional or illegal in terms of getting information about you. So a lot of times, if you are a victim of domestic violence, defense attorneys may ask for your history, your past relationships, any type of false reports that you've made in the past. Obviously, those are relevant, but those are types of informations that the opposing counsel may ask about you. And that can be obviously very intrusive. So you would need your own representation to make sure that that is limited in terms of your exposure. In family court, a lot of the cases in family court are self-represented in terms of basically you represent yourself, what we call pro per or pro se. So in terms of family court, you are not given an attorney, you're not given a pro bono attorney. You would either have to hire an attorney or find someone who will do it for you on a pro bono basis. But like I said, there are legal aid centers out there, a lot of domestic violence shelters that will assist you. And the legal aid center in each courthouse is able to provide you some type of guidance. They're not going to represent you in court, but they will give you the basic understanding of how to fill out forms. But keep in mind that they are free. It's going to be very limited in terms of how they will help you. But the short answer is you would have to hire your own attorney in any case, criminal context or family context.
And I would just like to add to that answer that victims or certain types of victims might also have relief in civil court. They might be entitled to compensation under civil causes of action. And in those scenarios, they would also need to get their own representation. The state will not provide them with one.
Attorney Ballamero brings up a good point. In the criminal context, there is what's known as a victim advocate. So if a criminal case is, if you report a criminal incident, even if a criminal case is not filed, a victim advocate is assigned to you. And that victim advocate is not an attorney, but that victim advocate is able to help you fill out forms in terms of seeking reimbursements from the state or reimbursements from the perpetrator in terms of restitution, lost wages, medical expenses. That victim rights advocate or that victim's victim advocate is able to provide you assistance with that.
Okay, thank you for those explanation for those important points regarding representation. As I said, some people are probably hesitant because of that aspect of preparing a case against the perpetrator. Now, something related to that and is on the question of whether withdrawal of the case. So if the victim files a case and then on the basis of filing that case applies for a U visa, and then at some point the victim withdraws the case, would that affect the U visa application of the victim?
Yeah, that's a good question. I actually don't know the answer to that. Well, because I think probably it would weaken the case, because I know that for, let's say you were approved for a U visa, but you didn't apply for a green card for whatever reason. In order to renew that U visa, you'll have to continue to have been helpful if you've proven to be difficult in aiding in the investigation or the prosecution down the road. That could impact the renewal. But I don't know the answer for sure if the U visa is pending and you decide to withdraw.
Yeah, we actually have a case that we're handling now that similar, wherein they don't want to withdraw the case because there's a pending visa application. So that was a good question that we really wanted to see what could be the answer, because they said they didn't want to withdraw it because if they withdraw it, then the visa application will not go through anymore, and that they will have to, and because of the case, the victim might have to be, I think, deported, or the perpetrator would have to be deported. So that's an issue that we're currently handling in one of our cases.
Yeah, just to add to Attorney Maridex's answer, like what Attorney Adrian was saying earlier, it's not actually the victim who is prosecuting the case. Okay, once you file the police report, if a case is filed, then the prosecutor, the city attorney, is the one that's prosecuting that. And in certain situations, even if the victim wants to withdraw his or her complaint, the case might still continue. It doesn't automatically mean that the judge will agree and dismiss the case, especially in cases of domestic violence. I've seen a couple of cases where there's already been a reconciliation, or the victim wants to withdraw, but it's not automatic.
That's absolutely correct. And with regards to the U visa certification from law enforcement and prosecutors, I have had instances where we have been asked to quote unquote recertify the prosecutor affidavit. So immigration had contacted me after having submitted the certification, and asked if they were still cooperative with the prosecution of the case. So that has happened a couple of times. So I think the question was if they would decide to withdraw. Basically, they become uncooperative at some point during the pendency of the U visa. Will that affect the viability of the U visa? And I would say absolutely yes, especially if the immigration officer reaches out to the law enforcement agency or the prosecutor and asks that law enforcement agency or the prosecutor to recertify it. The cooperation of the applicant.
Okay, thank you very much for that. Now, we do not have any more questions, I believe, but I would like to pose a question to our resource speakers. And that is, in the case of a victim, whether it is the wife or the child of the perpetrator, and the victim is already back in the Philippines, how do they go about? Let's say they did not decide to bring a case against the perpetrator while they were in the US, but when they went back to the Philippines, they decided that they now would like to pursue a case against the perpetrator. How do they go about that? And then in the case of a victim whose US visa has already expired, would they be able to apply for a view visa, let's say from the US Embassy in Manila? Thank you.
is such a relief as consular processing, where you file the U visa with the USCIS, which is the agency in the United States, and that's just for the petition part. But if you are outside the US, you can consular process. That doesn't mean that there aren't, well, theoretically, there's nothing stopping, but it does pose some challenges in that you do still need this thing called biometrics, which is fingerprints to run a background check, which the embassy should be able to do that, but in practice, it's a bit difficult at the U.S. Embassy in Manila, per se. But also, I guess it just depends on the timing. Like, was the helpfulness that you provided when you were in the United States enough to, I suppose, review the case? Because if there is an ongoing investigation and you're already gone, you might run into challenges meeting the criteria of helpfulness.
A follow-up question, Attorney Mariadex, would time be a consideration? For example, would the U.S. Embassy be entertain an inquiry regarding filing a case based on the VAWA if a lot of time has elapsed before the victim actually comes forward with a complaint?
For the U visa, you mean?
Yes.
Yeah, time is certainly a consideration for the U visa, but it isn't a time barred. It's not a time barred relief, but it also, to clarify, the embassy itself wouldn't be deciding upon the eligibility. It's still first and foremost a USCIS in the United States. For VAWA itself, as Marlon said, that there's a statute of limitations. You either still need to be married to your abused spouse or within 2 years of your divorce.
All right. Thank you
And you
for
can
that.
apply for a VAWA while you're in the Philippines under certain circumstances.
Right. Yeah, and so far as the last set of questions, actually all the questions from this evening are concerned, some of them did sound case specific. So I just want to reiterate that none of these statements that we've made today or this evening are the opinions of the Philippine American Bar Association or PCGLA, obviously, and none of the statements that we made is intended to be construed as legal advice or to create any type of attorney-client relationship arising from the statements that were made this evening.
Yes, thank you, Attorney Adrian. Yes, I think we need to reiterate that to our listeners and those who are watching us from Facebook. Thank you very much for answering the questions based on the presentations that you made for us this evening. And now I will pass the floor to Consul Maynard once again. Thank you.
Thank you, Consul Alni, and thank you again to our presenters for your contributions and your answers to the questions. That wraps up Empower Month, Empowering Women by Emphasizing Domestic Rights webinar today. I would like to thank again our presenters, Attorney Adrian Rojas, Attorney Mariadex Abraham, Attorney Marlon Baldomero. Thank you for sharing with us your knowledge and expertise on this highly important topic of domestic violence. We hope we can invite you again next time on other legal issues that our audience needs some guidance on. Thank you again. Keep safe, everyone. And thank you once again.
Thank you very much for having us.
Thank you.
Thank you.